And recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning, Council.
Good morning.
I am Justice Rubin, and I am joined today by two outstanding colleagues, Justices Neyman and Ditkoff. We will be hearing 6 cases this morning. This is the first. We are, of course, on teleconference due to the ongoing pandemic. The rules for argument are the same as they are in the courtroom, which is to say 15 minutes per side with no rebuttal. The first case we'll hear this morning is number 19-1650, Commonwealth versus Lopez. And we will hear first from you, Mr. Madison.
Thank you, Your Honor, and may it please the court, Nick Madison for ISRA Gonzalez Lopez. Mr. Gonzalez Lopez is making 2 main arguments on appeal. First, that the evidence at the suppression hearing did not establish probable cause to believe that there were drugs or other contraband in the car at the time of the search in this case. And second, that the evidence at trial of drugs hidden behind a panel under a steering wheel of a car that contained a passenger and was neither owned nor registered to Mr. Gonzalez Lopez was insufficient to establish knowledge of those drugs or ability and intent to control those drugs. Turning to the substantive, to the probable cause issue, I'd like to begin just by noting that there are several findings in the motion judge's findings of fact that are clearly erroneous. I argue those at some length in my brief. I won't repeat myself here. Suffice it to flag that for the court's attention. Moving on to the substantive question, I think it bears starting with the premise that the threshold here is probable cause. Immediately after arresting Mr. Lopez on an unrelated warrant, Trooper Strong conducted an investigatory search of the car in this case, necessitating a finding of probable cause to justify that search. Under the automobile exception, the standard is there probable cause to believe that there are drugs or other contraband in the car at the time of the search?
Mr. Madison, how would you distinguish the Lawson case?
Yes, Judge Neyman. So the Commonwealth does rely on Lawson. That case is there was a drug dog, a trained canine that alerted to the car in that case prior to the search.
But before you get to that distinction, it seems to me that the argument was that the Commonwealth needed probable cause to authorize the canine sniff. And the court also held, I know you say dicta in your brief, but they said there was probable cause to search the vehicle with or without a drug sniffing dog. So at least for purposes of my question, assume that the drug sniffing dog doesn't add anything to the analysis, okay? So the question is, with that background in mind, how is this case distinguishable from Lawson?
Sure. Putting aside the issue of the canine, there are multiple facts that added to a probable cause analysis in Lawson that are not present in this case. Most notably, in this case, there was evidence of multiple air fresheners being in the car. But there was not an inference given the testimony either at the motion to suppress or at trial that those air fresheners exuded a scent, which in my principal brief, I cite LOPEZ treatise. In my reply brief, I believe I cite a footnote in Lawson that talks about the incriminating character of air fresheners is due to their ability to exude a scent that's an attempt to mask the scent of drugs.
Okay, but why can't we, obviously there are, and as you described in your brief, there are some other problems with the air freshener evidence, but assuming we somehow find that it's adequate, or that, I don't even know how we would do it, take judicial notice, or maybe the cross-examination, we'll ask your sister about that, was enough to link it to drug transportation. Putting it all together, can't we infer at least the following? The car had been used in the past or was being used to transport drugs. That is, otherwise, what's the purpose of the 7 air fresheners in it? And then you add to that, the driver has an open warrant for dealing drugs. He claims not to know whose car it is or who the person is who owns the car, which itself may be indicative of something nefarious anyway. Is that much weaker than Lawson, really?
I believe so, Your Honor. In part, Lawson had additional entirely separate inculpatory facts, including that the car in that case was wanted in connection with the shooting. The defendant had declined on several occasions to provide identification, despite the fact that it was in plain view of the police officer who was making the stop. And so there were several, it was parked in a high crime area illegally with its lights on and its engine running at night. There were several additional inculpatory facts that I would say that aren't existent in this case. Going to what can be inferred here, I'm not sure that the fact of multiple air fresheners being in the car allows the inference that or provides a particularly strong inference that the car had been used in the past.
Well, except that at one point, the day they were put in, presumably they smelled like something, right? They're air fresheners. So on that day, you certainly would have, I'm not saying by itself, but that would have counted as something suspicious.
That would, so 2 responses to that. One is, it's not, I don't think that you can necessarily infer that all of the air fresheners were put in at the same time. It could have been that they were put in serially, and that they were expended over time and just somebody was too lazy to throw them out. The second is, I'm sorry, I lost my train of thought about what the second was. So I will, unless there's further arguments, I would compare.
I actually do have another, excuse me, question. You state in your brief, I think, something to the effect that or I think it's your reply brief, that the difference between Lawson and this case with respect to the air fresheners is that in Lawson, there was testimony from a police officer as to the significance of the air fresheners, whereas in this case, there was not. Is that a distinction you're making? Or am I misunderstanding what you say in your reply brief?
No, there's 2 distinctions with regard to the air fresheners in Lawson and between this case. One of them is, as you're pointing out, there was testimony in that case about the significance of the air fresheners from the officer. And I would say that to draw the inference, that testimony relying on the experience of the officer is required. The second distinction is, in that case, the evidence was that the car, quote unquote, reeked of air freshener, which provides more of an inculpatory inference that the air fresheners are presently being used at that point to mask the scent of drugs. Those are the 2 distinctions with regard to the air freshener that I would draw from Lawson.
So what of the fact that in this case, there was testimony from an officer about the meaning or significance of the denominations of bills among the $1,000, whereas in Lawson, there was no such testimony from any officer about the significance of the denominations?
Are you you're referring to the motion to suppress?
That's what we're still on, yes.
Yes, okay. So there was testimony there that the officer believed that small denominations of bills can be consistent with drug dealing.
Right. And there, at least as far as the case indicates, there's no such evidence that was present in Lawson. So was that a plus factor here that was not present in Lawson?
The court certainly can consider the amount of money. I would argue that one bundle of money is not a particularly strong inference that can be drawn in favor of drug dealing, as opposed to multiple bundles in different pockets or in different places. Or in
Do we know in Lawson how the money was grouped?
I don't believe. I don't recall that, and I'm not
actually. I can look. I can look at it. I actually have it in front of me.
For
So.
4 sets. That's all we know. Sets.
Thank you,
14
Judge
sets.
Ditkoff. I would, to close out the probable cause issue, just draw the court to the case of Commonwealth v. Amato, although in a slightly different context, I believe is analogous here. In that case, the question is whether or not there was probable cause to believe that the defendant had drugs secreted on his person to justify a strip search, as opposed to in the car in this case. And in that case, the defendant had a arrest history, made a furtive movement during the car stop, was nervous during the car stop, even though the officers had prior experience with him when he was somewhat gregarious with the officers, had $500 in cash in his pocket, and an object in his groin area. And the court in that case said that did not amount to probable cause. And further, it pointed to a distinction that I believe is important in this case, that heightened suspicion is not probable cause. That's the line directly out of the case. And I think there needs to, as applicable to this case, there's an important distinction between facts which are generally suspicious and a substantial basis to conclude that there are drugs in the car at the time of the search.
Can I ask one other thing? I'm now looking at Lawson's 14 bundles, not 4.
Yeah, 14.
14 bundles of cash. Do we know that this $1,000 was not in bundles? That is there any testimony? I know there's no testimony like these were crisp and clean, like you might get. I understand there's testimony could have come from an ATM, but is there specific testimony about how the money was arranged? That is, that it was all one bundle, and of course I have in mind that it's the Commonwealth's burden, but is there any testimony about that?
Testimony at the motion to suppress hearing was that the officer felt a bulge in his pocket, he pulled it out, and that's where he found the money. So we can infer from that, I believe, that it's in one bulge. I don't believe, again, cognizant of the Commonwealth's burden, that there's much more to infer to it other than the fact that it was in one bulge, for lack of a better term. Okay. Turning briefly to the constructive possession argument, I would note just very briefly that, and I get into this in my reply, I won't repeat myself now, there are certain facts that the Commonwealth argues in its brief that are either not in evidence during the trial or are unreasonable inferences from the evidence at trial. Again, I'll just flag that for the court. I would, as my time is running short, just note quickly that where the drugs are found hidden, not in plain view, in a car that is driven but not owned or registered to the defendant, that contains a passenger at the time, the Commonwealth does have, cognizant of the Lattimore standard, even with the Lattimore standard, they need to establish or adduce evidence that allows beyond a reasonable doubt, eliminates the possibility beyond a reasonable doubt that the defendant drove the car unknowing of the fact that these drugs were hidden in there. And I would direct the court to the Movilis case cited in my brief. That is, I would argue, a very analogous set of circumstances with hidden drugs in a car not owned or registered to the defendant. And then just as to the ability and intent to control, I think the holding and the analysis of Romero is very important for this case. In the Commonwealth's brief, they bundle certain facts together and say that that is sufficient for the to show both ability and intent to control without breaking out the analysis as to either. And so they consider proximity both as to ability and intent to control. Of course, the lesson from Ramiro is proximity is not sufficient to establish both ability and intent to control. You can have the ability to reach out and grab something. That doesn't mean that you necessarily have the intent. There
So
needs
can I ask you a quick, you only have a few seconds, but a quick
Absolutely.
question about this. Drugs are found, let's say, hypothetically, in the console between the two front passengers. Under your theory, why wouldn't everyone go free?
Of course, the question would be what other indicia are in that case. It is possible if the only indicia was that there were 4 people in the car and drugs in a equidistant to each of the passengers with no other linkages. At that case, the owner and operator of the car may come into play more, and the continuous possession may come into play more. But it's impossible if that's the only fact, the equidistance, that is possible that the Commonwealth can't meet its burden as to any of the passengers.
Okay, your time has expired. Excellent
Thank
argument. Thank you very much. Very well argued. Attorney Sullivan, we'll hear next from you. Well, you're on mute, Attorney Sullivan, so.
Hold on.
Ah, there we are.
Okay. I was so busy muting myself, I forgot to unmute. Good morning. May it please the court, Catherine Sullivan for the Commonwealth. With regard to, I forget which justice asked the question about the money that Trooper Strong found on the defendant. Trooper Strong mentions that it was in pockets, plural. He doesn't.
At the motion to suppress?
At the motion to suppress.
Where would I find that?
Yep, hold on. I'll look for. I just read it. And then he also says pages 10 and 17. And then he said it was found in shorts that he was wearing under his pants in pockets.
Okay.
Motion hearing, page 10.
Yep. He had $1,000 in his pockets, all in $20 bills. And then said that people that are involved in the sale of narcotics often receive sums of 20 in small denominations. And then later on, he testifies that I believe he was wearing jeans. I believe the money was located in shorts. So underneath his jeans, he was wearing a pair of shorts, and again refers to pockets. So at a certain point, I thought he said,
Well, the question refers to pockets.
Right.
Well, I don't think he's really adopting that. The question is, you didn't find any plastic bags in his pockets. Well,
well, on page 10, he does refer to pockets, plural.
on page 10, I didn't see that. Hold on.
Line 20.
Okay.
He had $1,000 in his pockets, all in $20 bills.
Okay. Interesting.
So that's the answer to that.
Can I ask you a question about the air fresheners? Well, actually, let me ask you a question about the probable cause. Of what crime was there probable cause?
Possession of cocaine. Or criminal activity related to the possession and or distribution of cocaine.
Cocaine. I've never seen a case where air fresheners, I know I saw a citation to like a 128. I've never seen a published case where air fresheners are used to cover the scent of cocaine.
And at trial, Sergeant Conant testified specifically to that.
Okay.
So
fine, that's a trial.
Right.
But
right.
I'm asking about the motion to suppress.
So Trooper Strong did not testify specifically.
But I'm just trying to figure out what we can do here, because maybe we ought to take judicial notice or something of the fact reported in many decisions that air fresheners can mask the scent of marijuana. But unfortunately, and I don't know why, I'm guessing you were not the motion counsel. but the crossing of T's or connecting of dots was imperfect with respect to the air freshener. And so we don't really even have a statement that air fresheners are a sign of drug dealing, even though all five of us sitting here know, of course, they are.
And to that point, just let me interject a little bit that I think the judge reasonably inferred from defense counsel's question that the trooper made the connection between the presence of the air fresheners and the presence of drugs.
We get into a very tricky, right? I mean,
Right.
It's a compound question, and what does not rejecting it, is that an adoption of the premise? It's not the best, right?
It's not the best, but it's certainly a reasonable inference. And I think what's also important.
But I'm asking about cocaine. I'm asking about cocaine because that seems like Lawson's a marijuana case.
Right. So I would have to find you a case specifically.
Well, I've looked. I mean,
Right.
I haven't thought, I won't say I've canvassed everything, but I looked certainly in Commonwealth cases, and at least my quick look didn't turn anything up. And I did see, I think it must have been in your brief, citation to a couple of cases that talked about it. I had always thought that powdered cocaine, I don't know what kind of cocaine this was, that powdered cocaine was an odorless powder. But I don't know. And again, I'm not saying I would take judicial notice of that either. So no, if someone told me cocaine smells like something, I'd say like, oh, okay.
Right.
Okay.
Exactly. And luckily, I mean, good or bad, none of us know really what that smells like.
I don't know if none of us know that, but all right.
Okay, I'll just,
You and I
guess what I don't want to lose sight of is the intent to mask the odor of drugs, right? And so.
Okay, but drugs is a little tricky because of the weight problem with marijuana.
Right, and to the extent that there's never been a suggestion that he was stopped, there's no evidence whatsoever of any crime related to marijuana specifically in this case. And I think it is important.
Unless the air fresheners are, right? People have been known to deal more than one kind of drug, but all right.
I think it's a fair inference that there were air fresheners, which the driver sought to use to mask the smell of drugs generally, or intended to use to mask some scent. Right. And
the officer testifying that he doesn't recall if they smelled.
I don't think that that's an essential element, because it's the intent, it's the purpose, it's the intended use of the air fresheners. And so it's the number of them and the inferential intent to mask the odor of drugs. And that's a common feature of all the cases that discuss the use of air fresheners in relation to criminal drug activity. So I think that's the point, I'd like to, the court to focus on. So I agree it's imperfect, but it certainly was reasonable for the judge to conclude that. And to Justice Neyman's point, Lawson stands very, very close to this case with regard to probable cause to search the vehicle. One thing that Lawson doesn't specifically address, which Trooper Strong testified to here, is that based on his experience, he had found drugs in exactly the same spot in cars before. So that added to his.
No, that doesn't help us at all. Right, that's what he found when he searched. That's not right. That's not something that every car has a fuse panel.
He was very specific in his testimony that he had found drugs in this exact same location in similar cars before.
How does that give it? Wait, so driving one of these cars is suspicious? I really don't get that.
No, but I think it added to his calculus in determining, that warranting his search behind the panel for drugs. He wasn't just,
Oh, look, either he could go in the car or he couldn't. I mean,
Right.
if they've been in the console, I've seen a zillion cases where the drugs are in the console. You know what I mean? But that doesn't make it more suspicious to have a console in your car. Or,
right,
it may explain why the officer goes right to it, but.
exactly. And as far as the sufficiency of evidence goes, the defendant was the driver here, not the passenger. His location, approximate location to the drugs is a factor to be considered. The fact that the air fresheners were there, whether or not they smelled, his nervousness, his large wad of cash which was inferentially from drug sales, and his outstanding warrant for, drug distribution, certainly all added to the judge's calculation.
Was the open warrant for a specific type of drug distribution? I don't recall.
I think it was cocaine. Also, the defendant stated that he had the car for a week. So that was that indicated some level of control over the car. He did not know the driver. There's some discussion in Lawson about the expectation of privacy that the driver had in the car, and that was mentioned at the motion hearing. I did not address that in my brief, but it's unclear how the defendant could claim he had an expectation of privacy. And I know he suggested that, the ADA suggested that to the judge at the hearing. So I just want to alert the court to that. Taken all together, I agree with the defendant that if one of these factors were present, it likely would be insufficient evidence to warrant the denial of the motion for required finding, but that's not the calculus that the judge is required to make. He's required to, undertake an analysis of the combination of factors here. And altogether, these factors contributed to sufficiency. And I guess if there are no further questions, I rely on my brief for the remainder of my argument.
Just well briefed by both parties.
Yeah, very good arguments by both of you. Very helpful to us. Very well argued. Thank you.
Thank you.
The case is submitted.
All right, we are live and streaming.
Good morning, counsel. Welcome to the appeals court. The next case we'll be hearing is number 19-1256, Commonwealth versus Felici. The rules of argument, we are obviously holding this argument by teleconference due to the pandemic. The rules of argument are the same as they are in our courtroom, which is 15 minutes per side with no rebuttal. And we will hear first from you, Mr. Harper-Nixon.
Thank you, Your Honor. May it please the court, Matthew Harper-Nixon on behalf of Mario Felici. This case involves the trial judge erring by excluding evidence proffered by Mr. Felici, which would have contributed to his defense. Those errors were then compounded by the trial prosecutor, referring in her closing argument to the lack of any such evidence that she had already successfully excluded. I'd like to start later in the trial with the investigator's evidence. This was the evidence proffered by Mr. Felici from investigator Tetro. The judge here did have discretion to determine whether or not to omit this evidence because, as I've certainly conceded, there was a discovery violation. He had an obligation, trial counsel, to inform the Commonwealth to borrow the term, sum and substance of investigator Tetro's testimony, and he apparently did not do so. I've seen nothing that suggests that the Commonwealth's surprise here was in any way, shape, or form not valid. Apparently there was a notice of the name because the name was read to the jury, but certainly I don't think that there's any claim to be made that, in fact, that the Commonwealth was properly noticed of the testimony that was to be presented.
So in other words, you're acknowledging that I think the first three of the 5 Durning factors are present here.
I would say that's right. Bad faith may be a little bit on the edge. It may become a question of mistake versus some sort of intentional action necessarily. So I wouldn't go quite so far as to say that it is met, but certainly surprise. And I would suggest there is some prejudice too. There's no question I think about that.
So that brings us, at least that brings me then to the proffer that was made. Can you remind me, my understanding is that the defense attorney basically said, my investigator took measurements, he used a measuring device and compared it to the surveillance video. And from that, he would offer his opinion that the assailant looked more to him like he was around 5'6", as opposed to 5'10" or 5'10.5", correct?
That's approximately right. Yes, Judge. As I understand it, the investigator first watched the video, and the idea was there were the video is of a chapel, so it's an enclosed space, and there are certain fixed structures within the chapel. And the investigator was comparing footage from the video of the person who committed the crime up against, say, for instance, a sign on the wall. He then, to the best of his ability, went to the chapel physically and measured approximately where that person was standing vis-a-vis that sign on the wall, coming up with the conclusion that the person was approximately 5 feet 6 inches tall.
So was the video included in the record for us to review?
I don't know. I did not specifically ask to have it sent up. I certainly can, if it would assist the court. It was definitely admitted at trial and was played for the jury. So it's certainly within the record.
But we can't tell, can we? So how would I put this? This goes to both the question of whether it's lay evidence and I think to the final two factors. I can imagine something like this being complex and requiring expert evidence. The camera is at a certain angle, the person is a certain distance from objects, and so on, right? And you have to say, well, or there's two cameras, right? You can come up with lots of ways that figuring out the height of someone in a video would be very tricky. On the other hand, you can also imagine a video in which a person is standing right next to a painting and he comes up to exactly the top of the frame. He's against the wall. And then you go and you measure the wall and you say, well, the top of the frame is 5 feet 6 inches from the ground or whatever. We don't know what this is, do we? We don't, even if we look at the video, we don't know what it is he measured against what. And then my question is, what do we do with that? It looks a bit to me like this started to be the discussion, and then the judge went off on didn't do the 5 factors, but just went off on this as a sanction, never really got to the issue of, is this, something a layperson can even testify about? So what will we do?
In terms of a remedy?
Well, is it a failure of the trial counsel to present adequate information so that the judge could do this? Or if the judge sort of shuts that down or, takes a left turn, does the trial counsel still have to make a better proffer, more detailed? Well, I guess I just don't, it's an odd circumstance to me.
It is, and the record here isn't perfect. I will certainly acknowledge that. But I think trial counsel, to the best of his ability, described what his investigator was looking to do. I would suggest that this actually gets to the issue of the sanction that you just mentioned, Justice Rubin. Here, the judge's decision was to exclude this evidence entirely. I would suggest, based on the Durning factors and PAVA that I cited in my brief, that there actually was substantially more that could be done to address this question. Because in fairness, you're right, we don't know exactly how the methods were employed. And to the extent that the Commonwealth objected to that in terms of her trial prosecutor's objection to the sum of substance, that was a fair objection. So I think there were other options that would fall short of full exclusion.
Why wasn't this defense counsel's burden? This wasn't rushed. There's even a recess, a 15-minute recess while the judge is thinking about it. And he talks about it for pages of transcript and finally says, this is essentially a demonstration or experiment. Why didn't the defense counsel, that's not the case, have an obligation to the judge to say, no, it's not a demonstration or experiment. because all I really want to say is the painting is 5 feet 6 inches high, and you can figure it out from there.
Well, to the extent that he had some burden, I would suggest his argument was that this was a relatively straightforward set of testimony from the investigator. So, and his term was a little flippant, I suppose, but referencing everyone knows how to use a ruler. I will say that to the extent that the Commonwealth in its brief suggests that there was substantial argument about whether or not this was acceptable evidence, I don't think we quite got there. If you read the transcripts, there, as you say, there's 6 pages of discussion about this. The majority of it is based on the discovery issue. That being said, to get back to the issue of a sanction or some other action short of exclusion, if the Commonwealth had a concern about the methodology or his employment of certain steps, maybe a Daubert-Lanigan hearing would be appropriate. I mean, you could do that relatively quickly within the course of a trial. And I respect that there is a...
How would we do a Daubert-Lanigan hearing on measurements in the middle of a trial when neither party has an expert on that to testify? I mean, we'd have to wait months, wouldn't we?
No, I don't think so. I think that, again, this gets back to the question of whether or not this was sophisticated evidence versus relatively, sorry.
Oh, well, so if it's not expertise, sure, but for a Daubert-Lanigan hearing, we have to have experts, right? How would you find experts in any short period of time?
And that gets to another question, is this is, if this were a circumstance, say, for instance, of DNA testing or chemical testing of substances, this is not a drug case, obviously, but if it were a circumstance like that, I could see the sanction of exclusion being more proper. As I understand the proffer of the evidence here, I mean, it's what we have is in the record. The testimony was to be that the investigator went to the scene and took a measurement. My understanding is that district attorney's offices in every county have Massachusetts state police troopers who are assigned to assist them with investigation. They take measurements all the time. The analogy, the best one I've come up with is the circumstance, and again, not a drug case, but where you have a school zone enhancement on a drug charge. You, generally speaking, have a police officer or a state trooper come in and tell the jury how it is he came about measuring.
Yeah, but he says, I use this wheeled thing that has a counter on it, and I wheel it from the front of the school or the edge of the property, whatever the rule is, to where the drug sale took place, right? And then now maybe I'm going to say, I don't know, expert, lay. I mean, I don't know if they're trained to be able to say how whatever that thing is, not quite a pedometer, how that measurement device actually works. I have no idea. Or why it's accurate. I assume you could cross-examine on calibration, you know, like you would with a drug test or a speeding gun. But that's a little different than saying we're missing some data here. Let me ask you this, though, about the 4th and 5th factors. On the one hand, we have case law that says the judge has to consider these. The judge gave no indication explicitly, and I'll ask your brother this too, of having considered them. I'm not saying the judge didn't consider them, but it doesn't, there's no explication of them. But as I look at them, the effectiveness of less severe sanctions. So I try to think about what would be a less severe sanction. Is that what I'm supposed to be doing, or I just stop when I find the judge hasn't said anything explicitly?
I think it makes some sense to take a look and consider what a less severe sanction would be.
How can I do that? No one presented any suggestions to the judge. Now I can make some up. So for example, instruct the jury that the Commonwealth didn't have a chance to do its own measurement. That's not a great, if I were the trial judge, I wouldn't love that. Take a recess from the trial and let the Commonwealth go with its tape measure over to the place. I guess. I mean, it's less severe, but it's, I don't know. It's tricky. So what's your thought on less severe sanction? And then let me actually annoy you by compounding the question and asking you about, because I'm dominating the argument, which I don't like doing, and yet I do. The 5th factor, materiality. Was there any other evidence about height in the record. All right, so go ahead.
Well, to address that first, I think it's fairly easy. The one bit of evidence that the investigator was allowed to testify to was that Mr. Felici was approximately 5 feet 10 to 5 feet 10 and a half inches tall. And I think that was based on some examination of records, R&B records, as I recall. So to the extent that that was going to be potentially an issue, that would get to the materiality. And then also the only defense
Wait,
really
there's no evidence. There's no evidence about the perpetrator having been shorter than.
the only evidence would have
Yeah.
been the testimony from the investigator. So, and where this was an ID case, there was never any suggestion that this didn't happen. The question was whether or not Mr. Felici was the person who did it. That's my materiality argument, is it strikes to the heart of his defense, is that he was trying to present the possibility that someone else committed this crime.
So I
To
gather,
get back to the,
Counselor, I
sorry,
gather that on the video, I don't know if you've seen it,
I have.
that the defendant does not seem to be 5'10", and the dispute is whether he was crouched or not.
Frankly, it's hard to tell on the video what height his height is. There's no, this isn't a circumstance where there's some specific measurement device within the facility, like for instance, a convenience store or something. And yes, there is some possibility that he's crouching. It's a little grainy surveillance video. So the jury would have to look at it and have to consider that evidence that was before them and conceivably compare that to investigator Tetro's testimony. So they would have to make a decision which to credit. That was something the jury was going to have to do. Just to get back to Justice Rubin's question about lesser sanction, I think you hit it on the head, is my suggestion, is that a short recess would have been an appropriate step here. The Commonwealth seems to have been surprised by this. My suggestion, though, is that the Commonwealth could have had an opportunity to, first of all, maybe have a further voir dire of the investigator's testimony before taking the recess. So a further examination of what exactly it was he's going to testify specifically. And then, as you say, take their own measurements. Again, my understanding is that they have investigators working for them who are available to do this relatively quickly. I'm not saying it could take place in an hour.
Take measurements of what? I go back to Justice Rubin's question, and based on the proffer, I don't know what they would have measured against. So,
Again,
and my problem is that defense counsel, as far as I can tell, did not ask for a continuance, did not ask for a recess, did not ask for a voir dire, did not even ask for an alternative sanction. And I don't know how his proffer would enable the Commonwealth to do anything. I guess where I'm going with this is, why isn't all of this more appropriate for a motion for new trial?
Well, Your Honor, normally I would suggest that that sounds like an ineffective assistance of counsel argument, of course. And to the extent that that was the case, I understand that normally you would want to have that happen in a motion for a new trial. My position is that the proffer here, as it was described, and in the context of the argument back and forth between trial counsel and the trial prosecutor and the trial judge, was enough for the judge to make a decision here in a different use of his discretion. In that, my suggestion, I'm running out of time, I apologize, is that I understand my position is he abused his discretion by excluding this evidence and not taking some other step to allow Mr. Felici the constitutional right to present evidence in his defense while balancing the need for an orderly trial and the need for following the rules. So I'm out of time. Unless the court has any other questions, I'd rest in the brief.
Are out of time. Are there other questions? I see none. That's an excellent argument. Thank you very much. And we will hear now from Attorney Shepard-Brick. Oh, you're muted, Attorney Shepard-Brick, as happens from time to time.
Thank you. May it please the court, David Shepard-Brick on behalf of the Commonwealth. I take the arguments, I guess, in reverse order and talk about options for a less severe sanction. You know, the suggestion that the Commonwealth could simply send out an investigator and measure, I take it back to Justice Neyman's question, measure what? You know, I've seen the video. He's and we certainly can send it to the court. There's no instance in when he's standing very close to a wall. I mean, he walks in, strangles her, throws her up against the wall. What I would also say is he's wearing
the judge had not seen the video at this point. Is that right?
No, the judge had seen the video at this point.
The judge seen the video?
Correct. It was played during the victim's testimony.
I thought it was played after. Okay.
So yes, no. So the judge had seen the video, and you know, if you look at the video, he has a hood up. He does not appear to be standing straight up, and you know, he moves quickly into the room. You know, and this is, you know, I know the defendant has objected to my analogy of Chuck Woozy, but I think it's really pertinent because, you know, in that case, they had an expert and the judge still excluded it because the photographs used, as the court said, in the simulation showed the shooter was wearing loose-fitting clothing and a hood that obscured his posture and the location of the top of his head.
So,
we have all those things here.
let me ask you this. Your brief really argues this requires an expert. It doesn't make much argument, if any, about the factors. Is that because you think that because the judge didn't say what he or she was doing here, I don't know if it's man or woman, that we can't rely on those factors? I mean, there is some case law that they have to be, I don't remember what the phrase is, but the judge must make clear that he or she has considered the factors, and the judge didn't mention 4 and 5.
That's true. So he didn't mention explicitly 4 and 5. What I would say, I think
is that error, and then we have to decide if it was prejudicial.
Well, you know, I think it was implicit in his excluding it that he didn't believe that there was a lesser sanction that was available. But, you know, I think that this does come down, whatever avenue you look at it, under the prejudice analysis, which is the same as the materiality analysis. This evidence wasn't material because it simply wasn't admissible. It would have confused the jury.
There you go, back into lay versus expert. I can't tell because that discussion was truncated when the judge shifted gears and moved over to the discovery violation. Now, maybe it was the burden on the defense counsel. I have to look very closely at the transcript. I only read it once, so I'm not, you know what I mean? I'm not hyper-focused right now on the exact verbiage, but you know, it seemed like it was going one way, then it went another, then it was over. You know, the judge has already ruled this can't come in because of A. Is it the obligation of the defense counsel to argue then, in the midst of trial, although that's their own fault, to argue then, Your Honor, just for the record, in case it's reversed on this thing that you just said definitively, I'd like to say, you know, that it also shouldn't be excluded under B. And here's some more detail for you.
I mean, I would suggest that it is his burden to do that. I mean, the judge did say it was a demonstration of an experiment that had to be disclosed, but I think implicit in that finding is that it's the type of testimony that normally requires at least some specialized training. So whether or not, you know, that I would point to that language in the judge's finding. In terms of what, you know, this is, there was no motion for new trial here, so we don't know what trial counsel's you know, was going for here. We do know that the judge found that it was in bad faith, that he sprung this.
Yeah. Okay. I mean, okay. You know, I think that's a slight, you know, of the 3 that the judge did reach, that one seems a little, you know. But I grant, you know, something. Obviously, it was unfair surprise, and again, I don't know where this chapel is, you know. But the idea that the Commonwealth has to run over there with a tape measure, you know, while the jury is cooling its heels in the you know, jury room or whatever, that doesn't sound right to me. But or at least it seems like it would be within the discretion of the judge to decide that was not realistic. but I can't tell if this is lay or expert, but again, that may be a burden question. I'm just not sure.
Well,
Go ahead, please.
I'm sorry. I think it is a burden question, and the proponent of testimony that is potentially expert testimony has the burden under Daubert-Lanigan to show that it is admissible and that it meets the factors.
If it's expert testimony.
Right.
And I can imagine something a layperson could do, measure the top of a painting or whatever, that someone's standing up against the wall, straight and tall, hiding behind a, and say, look, the painting's like this, the guy's like that. And I don't think that's expert testimony. I don't know that that's this either, but it's not expert testimony.
Well, and I would say that that's not this. If you, again, we're happy to send the video. You can really see that you couldn't make that type of easy measurement on this video. And, if this had gone the defendant's way down below, we would be in a different situation. But the judge ruled, he was convicted. So this court is free to affirm on anything, on any basis that's presented in the record.
Can we discuss prejudice?
Yes.
So let's assume that there was error. I was trying to find cases like this in which either the SJC or this court had reversed for failure to consider all of the factors. It led me back to the Reynolds case, a case with which I have perhaps too much familiarity. But in that case, for example, the reversal was because, number one, there were multiple errors, not just a discovery violation by defense counsel. But number two, in that case, the key witness was a jailhouse informant. And on cross-examination, defense counsel, without having disclosed this to the Commonwealth, literally started taking out boxes of information and started taking out transcripts. And on the one hand, it was trial by surprise, which was inappropriate. On the other hand, what was in these transcripts were admissions by this same jailhouse informant that in prior trials, he had outright lied. I mean, it was exculpatory, it was critical information. By comparison, I look at this as potential lay opinion testimony that based on some calculation I made without more specificity, I think this guy could have been 4 inches shorter or 4 inches taller. So I guess that's a long way of saying, could you help me drill down on cases where there has been reversal in a context like this as opposed to Reynolds?
So I didn't come across any of them, and I think that might speak to the remedy here, which is that assuming that that the judge shouldn't have excluded it. The evidence here is a very minor piece of evidence that's not very persuasive. If it is allowed in, you have a layperson saying, this hunched over person, I think they're 5 inches shorter. And on the other hand, you have an eyewitness who knows this attacker, who is face to face with him in this video, had threatened her earlier in the day, which was corroborated. The threat was corroborated at part by the victim's husband. You have what she tells the police happened is almost exactly what you see in the video. What I would say is that the evidence here was incredibly strong, if not overwhelming, and this minor piece of evidence, even if it was allowed in, I would suggest would not have had an effect on the jury, or would have a very slight effect. And so I don't think the defendant can show prejudice.
I think I really would like to see that video.
We'll work. I'll work with defense counsel and we'll have it sent to the court.
Thank you.
I'm happy to answer any other questions the court has on the remaining issues. Or if not, I can rest on my brief.
I see no further questions.
All right.
Another great argument. The two of you have been very helpful to us. Thank you so much. The case is submitted.
Ready to
We are
start?
now live and recording.
Good morning, counsel. Welcome to the Appeals Court. I'm Justice Rubin. I'm joined today by my colleagues, Justice Neyman and Justice Ditkoff. The next case we'll hear is number 20-254, Commonwealth versus Rodriguez. Our rules for argument are the same as they are in the courtroom, although we are, of course, on teleconference due to the pandemic, and that is 15 minutes per side, and we have no rebuttal. And we will hear first from Ms. Shavitz. Oh, I'm sorry. No, that's wrong, isn't it? Ms. Johnson. No, Ms. Shavitz. That's, I'm sorry, the screens are confusing me. Go ahead.
Okay. Thank you, Your Honors. May it please the court. Abby Shivitz here to represent the defendant, Mr. Carlos Rodriguez. In this case, the trial judge abused his discretion when he impermissibly coerced the jurors into reaching a verdict by directing them to continue deliberation without their consent in violation of General Law Chapter 234A, Section 68C, after they had twice already reported deadlock. Now, the facts of the case reveal that the trial judge violated Section 68C as it is interpreted in the case law, and relief mandates a new trial here.
Attorney Shivitz, can I ask you two preliminary questions?
Yes,
The first is, am I correct that you're not challenging the content of the Tui Rodriguez instruction that was ultimately given?
that's correct. I'm not contradicting that, challenging that, just that the fact that it was given created coercion on the jury.
Now, my second question is, you stated your brief, I'm reading at page 28, the judge's actions prejudiced Mr. Rodriguez because the jury was forced to render a verdict on indictments 005 and 006. I'll stop there. So I then took a look and I read note F, and I read it in conjunction with note D. And it seems to me it's clear that the jury had reached guilty verdicts on counts 5 and 6 prior to sending note F to the trial judge. Why is that incorrect?
Okay. I believe that's incorrect because I think it's a speculation. They don't reveal the content of what was in what their decision was as early as note D. And we simply do not know until the actual verdict is delivered. I know the Commonwealth does try to argue that the guilty verdicts were already established at the end of day one of deliberation, but there's just no way of knowing until the verdict is delivered.
Your hypothesis has to be something like this. I don't think we should, if we can avoid it, I don't think we should be looking behind these verdicts to figure out what they were anyway. It gets, we do stuff like that sometimes, but it's always bothered me. But in any event, your hypothesis is, having unanimously agreed to acquit of the two charges of which the lesser charges, following the Tui Rodriguez instruction, the jurors went back feeling coerced to deliver a verdict, but ultimately only doing so on one additional count. They had a conversation sort of like this. There are holdouts with respect to a guilty finding, not guilty finding on the rape charge. And those who want the not guilty finding on the rape charge say to them, and this, I mean, it sounds improper, but of course jurors compromise all the time, say to them, look, we don't want to find him guilty of rape. If you insist on a guilty finding, these lesser charges that we've already all voted to acquit on will go along with that. If you'll go along with this, and everyone unanimously agrees. That's the only way that you're, I don't know the only way, but that's the most likely way that what you're describing could have happened. Is that right?
Yes, that's right. The fact that they could have gone from not guilty to guilty in the time period when between the time they had submitted note F and the judge delivered the Tui Rodriguez instruction, and when they returned with the last note, with the final verdict. But if, yes, go ahead.
Do you agree that prior to when the judge decides to give the Tui Rodriguez instruction, the judge has not found due and thorough deliberation?
Well, I would argue that it was clear that there was due and thorough deliberation.
Well, that's my
Right.
next question, but
Right.
would you agree the judge did not find due and thorough deliberation before that point?
Essentially, I believe that was the judge's position.
All right, so the next question, of course, is
Yes.
why did the judge have to find due and thorough deliberation at an earlier point?
Well, he would have to have found, well, under my argument, the judge would have to have found due and thorough deliberation in order for the statute to have been triggered. And I argue that basically when the jury returns with note E, which was, we're concerned, actually note E, I'm sorry, what happens if a unanimous vote can't be reached? And my argument is by that point, the discussions with the jury were due and thorough. And I believe they're due and thorough because you can look back in the context of all the communications, not just looking at one communication in a vacuum. They were definitely unsure at note C. At note D, they had not rendered all of their the complete verdict. So I think by note F, it was due and thorough.
Counselor, I mean, it actually happens that sometimes a jury immediately says, we're deadlocked, it's over, mistrial us. And a judge finds, this isn't due and thorough, this has been an hour, go back, and that's fine under the statute. You can keep doing that until you get to due and thorough. So why does it have to be due and thorough at that point? You're talking about what the jurors said, but even if they say we're totally deadlocked 8 times, as long as there hasn't been due and thorough deliberation, the judge can keep sending them back. So why does it have to be due and thorough at that point?
Are you asking about the facts? What would make it due and thorough at that point?
Yeah, why is it due and thorough at that point? It's not the jury saying it's due and thorough. It's whether the judge determines that he's had due and thorough. They've had due and thorough deliberation at that point.
Right. I think that the judge is supposed to go through a number of, in making his evaluation of due and thorough, he needs to go through a certain checklist and evaluate the case. And some of those include the complexity of the case. And in terms of complexity, this was an easy case. It was there was one single witness, no forensics, no corroborating evidence. There was no, the judge would also need to look at the extent of evidentiary conflict on material issues. And there really wasn't any conflict. It was a he said, she said case. And then the judge also needs to consider the total length of time of the trial and the total length of time that the jury spends trying to deliberate. And if you look at the trial itself, I calculated it turned out to be about a 6.5-hour trial. And you juxtapose that with the total length of deliberations, you have over 12 hours of deliberations. So I think when the judge looks at all those factors, he should be able to make a due and thorough determination. Of course, it is discretionary, but I believe that the facts of the case demand that he should have reached that decision by the time, I guess, note E. And then when the jury came back at note F, that would have constituted the second return after due and thorough without a verdict. And at that point, the judge should have asked the jury for their consent as to whether they wish to continue or they could go home. So again, I guess the focus for this case is that it really was a simple case. And by being repeatedly sent back into deliberation, the jury was subject to being compelled, and this was definitely an abuse of discretion.
Why is the complexity of the case a factor? I would say a critical factor, but a factor at all in this analysis? I mean, the reason I ask, let's say there's a very simple case, but jurors dispute or having difficulty determining who's credible. I mean, I've seen OUI cases where juries are out for 3 days, and there are homicide cases where juries are out for 3 hours.
Okay, and in terms of the question being why is this a complex case, or why does the judge need to consider the complexity as a factor in his evaluation?
The latter.
Okay, so I'm relying on the case law, Commonwealth versus Winbush.
I understand it says
right.
that. I'm curious,
Okay.
though, why is that a factor? I'm just, it's never made sense to me. That's why I'm
Right. Well, I suppose that if it's an easy case where there is no complexity, it would be much more straightforward, and it shouldn't require the jury struggling for hours upon hours, returning multiple times with notes about uncertainty about being able to reach a unanimous decision. So,
but it happens. This may not answer the question, but the
right.
scenario you just presented happens all the time. There are quote
Yeah.
unquote simple, straightforward misdemeanor cases where juries are out for days, and there are complex civil litigation cases where juries over a period of weeks, where juries are out for just a period of hours. I just don't understand why that is a relevant factor. I'm trying to, is there a history to that, or is there a purpose that the case law discusses?
I really don't know, I have to say, to be honest with you. Sorry about that. I just relied on it because of the established case law. And to me, this seemed like an easy case in that there wasn't a lot of, the only evidence was the testimony of the complainant. So if I could move on, in the Commonwealth's brief, they argue that the notes that the jury presented were really just asking for guidance. And I believe that the Commonwealth's interpretation of these notes is too literal, and they failed to look behind the notes to try and recognize the jury's psychology, and that the fact the jury had been struggling multiple times, coming back and forth. And if you look at note E, that was what happens if a unanimous vote can't be reached. That isn't just asking for guidance. It could also be read as a rhetorical question, like, what do we do?
Let me just to be clear, to follow up on what Justice Ditkoff was saying. Is your position that there are certain words a jury can use that as a matter of law trigger the statute? Or are we simply asking, is it an abuse of discretion for the judge not to find that that was the first one? That is the first return after due and thorough.
Okay. The argument is that the judge abused his discretion. With note E, I would argue that was the first return that was due and thorough.
I understand, but what I'm saying is it's an abuse of discretion standard.
Yes.
Right. So a judge can look at something and say, if there's a basis for it, I don't think they've really had due and thorough consideration. I'm sending them back. And unless that's an abuse of discretion, we wouldn't say, yeah, that should have counted as one. And what I'm trying to figure out is, are you saying that because of the words they used in this context where they'd come back before, sort of, I mean, I guess you must be saying, as a matter of law, at that point, that consideration was due and thorough? Or are you saying that we should be setting up a rule that says this, when they say we're deadlocked, let's say it actually said we're deadlocked. It doesn't quite say that. It says, what do we do if? But let's say your reading of it is they're saying we're deadlocked. Does the judge have to say, well, if they say they're deadlocked, that's due and thorough? Is that the rule? Where does the rule come from?
Okay. No, I didn't, to be honest, I did not find a lot of case law or any case law that really supported the exact factual scenario in my case, but I did look at Commonwealth versus Jenkins and the Justice Liaco's dissent, which I thought was very telling, because he said the statute really requires no words of any particular significance, no magical phrase, no words like hung, deadlocked, impasse. I don't think we should be focusing on the actual words, because the judge needs to look behind the words and to look at the entire context of how deliberations have been developing, and in the context also of the case itself. So I don't think and the Commonwealth is extremely focused in its brief, as was the trial judge, that the words weren't right. The trial judge argues or states that they use the word if, and I really don't. I think that's an abuse. I don't think that's what the statute is aiming at, looking at the particular term. So even if a jury says they're deadlocked after a couple of hours, I think it's definitely the judge's discretion to send the jury back and to see if they can work it out. But I think you have to look beyond the words and look at the full context and the history of the struggle of the jury. So that's what I believe that the case law and the statute is aiming at. So I know I'm running out of time quickly and I haven't gotten to much, but essentially, I believe that there's prejudice here and that the judge abused his discretion and that my client should be afforded a new trial. In terms of the other arguments, I stand by what was presented in the briefs, because there's no time to really get into that. Unless there are any particular questions, specific questions as to any of the other arguments, I will rest on my brief.
Counselor, can we get
Yes.
the motion in limine about the admission of the photos?
Yes, I'm sure that I have that in the file. So that was the one that was submitted prior to trial.
If you could reach agreement with opposing counsel about what the document is and submit it, that would be helpful to us.
Okay, I will do that. Thank you.
The motion is being discussed at page 36 of volume 1.
Right. Okay. Yes. Okay. Thank you.
Okay, thank you for your time. We do have your other arguments in the brief, and I think we understand them. Thank you for an excellent argument.
Thank you.
We'll hear now from you, Attorney Johnson.
Thank you, Your Honor. Good morning, and may it please the court. My name is Melissa Johnson, Assistant District Attorney on behalf of the Commonwealth. I would like to rest on my brief as far as the arguments pertaining to the photographs and the closing argument, unless there
Well,
are.
I'd like to, yeah, I have a question about the photos too.
Yes,
So maybe I'll start there.
I've gone through the, oh, go ahead, Justice.
Oh, they're the same question, I'm sure, so go ahead.
Well, I understand the Commonwealth, the judge has discretion to admit the photo.
yes.
There can be debate as to whether or not it's quote unquote necessary. Was there a limiting instruction requested here?
No, there was not, Your Honor.
Even in the absence of one, if you were trying this case, or if you were maybe conducting a seminar on do's and don'ts of evidence, would you recommend to the prosecutor to say to the judge, request a limiting instruction if you're going to submit evidence of this nature, whether it's of a homicide scene or a picture of a young child at the age that they were allegedly raped or sexually assaulted? Why not protect the record? Why not have that safety valve in there so that this issue isn't raised in the first place?
Well, Your Honor, I don't think it's wrong for a judge to sua sponte give a limiting instruction or for us to request one. And I'm assuming the limiting instruction would say something to the effect of do not be swayed by emotion or sympathy when you view this evidence, look carefully just at the evidence. The judge does give that at the end of the case. So the jury, that's the last thing that they hear, is that they have to look at the evidence, rationally and not be swayed by emotion. So that is given at the end of the case.
What's the probative value of these two photographs?
Your Honor, these two photographs go to two required elements of the crime, one of them being age. We do have to prove that the victim was under the age of 16.
And you think a photograph is how you prove that? Because you can tell.
It is one way we can prove that, yes, Your Honor.
Okay. She testified, right?
Your Honor, she was 22 years old when she testified.
That's exactly right.
That's true. And part of our burden is trying to bring this case, this difficult case, to the jury in the way that it was in the way that it happened 15 years ago. It's a very difficult thing to do. It's something.
Boy, you're not persuading me that it's probative. You are persuading me that it's inflammatory.
Your Honor, and there is another element that it is used to prove, and that is constructive force. Again,
and how many three-year-olds do you have to prove that with? You don't think that's res ipsa?
Your Honor, we have an adult woman who is testifying.
I agree with that, and that's why you introduced the photographs, but I just don't know what it's probative of, or at least I don't know why its prejudicial impact doesn't dramatically outweigh its probative value.
Your Honor, I believe it is relative to constructive force, to judging the size of the defendant vis-a-vis the victim. And that's very hard for the prosecutor to be able to show that in a way that is compelling for the jury.
You don't think saying this is a grown man, that's a 3-year-old, I can cover it. Seems adequate to me. I don't know. I mean, 3-year-old?
Your Honor, it's a difficult case. We have one witness who is testifying.
What do you mean it's a difficult case? You mean difficult to win? I agree, maybe. I don't know if I agree, actually. It may not have been.
For the jury to envision when the victim is a fully grown adult woman. And we're trying to bring this home to the jury as to what happened 15 years ago. So it is difficult, not only for us, it's difficult for the victim.
Wait a minute.
For the jury.
Element of the offense is that the person be a child of a certain age.
Yes.
The element of the offense isn't, look how horrific it is that the person is of that age. You have her right there testifying.
Your Honor, that's not what I'm saying. I'm saying we have to prove 2 elements here. Number 1 is age, that this person was under the age of 14 and under the age of 16 at the time that this occurred, and also constructive force.
Okay, I get it. If this were error, why isn't it prejudicial?
Why isn't it prejudicial?
If we assume it's error, and we have to deliberate about that, I'm not saying it was error, but if we assume for a moment, for the sake of argument, that the photos shouldn't have come in, how do we figure out whether it was prejudicial or not?
Your Honor, all you have to do is look at the verdicts in this case, and I quote, and I cited the case of Sosnowski in my brief. We have a jury here that clearly sifted rationally through this evidence, through this testimony, when they returned 2 guilty verdicts on the indecent assault and battery, were hung on 2 rape charges, and then came back with a not guilty.
So you're saying they weren't overly influenced.
No, Your Honor, I think the verdict.
Why wouldn't a single conviction, if the jury is hung, from the beginning they were almost hung, I'm not sure that the closeness of this doesn't sort of cut both ways.
Your Honor, I believe under the case law, under Sosnowski, and cases that cite Sosnowski, if the jury is able to rationally sift through this evidence and come back with a verdict, they could have come back all not guilty, they could have come back all hung, as they did before, but this jury came back and rationally sifted through this evidence to clearly come back with a not guilty and hung on 2.
I don't know if this is in the record, or we can take judicial notice of it. Did you introduce the photographs at the first trial that was hung?
Your Honor, they were introduced then.
They were introduced at the previous trial. All right.
If there are no further questions about the photographs or the closing argument, I'd like to move on to the argument regarding the jury, the deadlock jury here, Your Honors. Your Honors, this is clearly a case, as you recognize, of whether the judge properly exercised his discretion to figure out whether this jury was deadlocked and whether they had already gone through a due and thorough deliberation at the point where the judge gave the Tuya Rodriguez instruction. And if you look at the progression of the communications between the jury and the judge here, he did not abuse his discretion in any way, shape, or form. And certainly when he decided to give that Tuya Rodriguez discretion was well within the range of reasonable alternatives under the LL standard. If you look at the very first time they came back, as far as on the first day of deliberations, the first relevant note they have, they talk about the fact that they needed more guidance. If they had taken a formal vote at there, they may be deadlocked, and they needed more guidance. And the defense attorney and the prosecutor and the court all agreed at that point it was premature, any Tuya Rodriguez. And the defendant agreed not to give that instruction at that point, agreed with the court's instruction that jury needs to fully and carefully discuss the law and the evidence prior to making any kind of vote. So we have that at 3:10. Then at 6:13 that same day, the jury reports that they are unanimous on 2 the counts so far, and they want to continue tomorrow. So we know that at that point, they're not complete with their deliberations. They're ready to go forward. They've got 2 in the bag, and they're ready to move forward with the other 3. Now, the next morning, they come back at 9:13 a.m. 24 minutes later, they come back and talk about the fact that the instruction's clear as to the unanimous vote, but what happens if one can't be reached? And that's the one that my sister is saying, well, at that point, a Tui Rodriguez instruction should be given. Well, that's clearly not, and certainly the judge did not abuse his discretion in finding at that point Tui Rodriguez was premature. They hadn't gone through a due and thorough deliberations. Just at 6:13 the night before, they said they want to continue on the remaining indictments. And 24 minutes prior to this statement, they had just come back. So the judge certainly didn't abuse his discretion in finding at that point Tui Rodriguez was premature. They hadn't gone through that due and thorough deliberation that was necessary. And especially if you look at that communication itself, and I'm not saying I agree with my sister, there's no magic word for a jury to say, we're deadlocked, that's it, we can't go on. And I think the case law is clear about that. It's really what has happened before, up to the communications, to that point for a judge to be able to properly exercise his discretion in trying to figure out whether at that point the jury had engaged in due and thorough deliberations. And this judge certainly didn't abuse his discretion in saying at that point, 24 minutes after they had just come in for the day, that it was certainly not due and thorough. And in fact, at that point, he did cite the language that they said, what if a unanimous verdict can't be reached? And that is equivocal. So that certainly is not within the range of reasonable alternatives for the judge to say, you know what, not quite yet. Wasn't until about 3 or 4 hours later, at that point, the jury comes back and says, we conclude that we cannot reach a verdict on indictments 1, 2, and 3. We already have on 5 and 6. At that point, the judge and the prosecutor agree Tui Rodriguez is appropriate. So at that point, yes, the language was definitive. It was conclusive. They said they cannot move on. And I think under the Viega case, if there's something about that communication which says, look, it really would be fruitless if we went on at this point, we are reaching an impasse, some sort of communication like that doesn't have to have a magic word. But at that point, the judge gave the Tui Rodriguez instruction. And as I had said before, in terms of the prejudice, the jury had already reached a verdict on 2 of the indictments. And while I was not in the jury room with the jury, and none of us were, I think we can make a common sense inference that the 2 indictments that they reached a guilty verdict on were the 2 indecent A and Bs the night before. It would be highly unlikely at that point that they would have had a not guilty before, that they had switched around to a guilty at that point. I suppose in some alternate universe it's possible, but common sense dictates it's probably not possible. It was always a guilty verdict. And after that Tui Rodriguez instruction, one can assume that the jury came back, still hung on 2 of those indictments and not guilty on the other. So there is no prejudice to this defendant as to how this whole thing transpired. And so if there are any further questions on the jury instruction issue, I'm happy to take them. Otherwise, I will rest on my brief.
I see no further questions. Excellent argument, Attorney Johnson and Attorney Shayevitz. Both of you have done a great job. And
All right, we are live and recording.
good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Neyman and Ditkoff. The next case we will hear is number 19-1095, John Doe 321579 versus Sex Offender Registry Board. This is an impounded case, so I trust that the attorneys will take care to comply with the impoundment order. We are, of course, hearing this argument by video conference due to the pandemic, but the rules remain the same as for argument in person at our courthouse, which is to say 15 minutes per side with no rebuttal. And with that, we will hear first from Attorney Tenen.
Thank you, Your Honor. Good morning. Eric Tenen on behalf of John Doe, appellant in this case. This is, I think, a relatively straightforward appeal of a SORB classification, of which I'm sure the court is familiar with at this point. Two, again, straightforward issues. The first is just whether there was substantial evidence to warrant the level 3 designation, and sort of a sub issue whether the hearing examiner correctly applied some of the factors. And then the second issue just has to do with whether it needs to be remanded for specific finding regarding internet dissemination. So just on I'll start with the first issue about whether there was substantial evidence. Just to set the table a little bit, this is a case where the hearing examiner made a series of findings about which factors he found applied. He did not find any of the so-called high-risk factors. The SORB regulations has a series of factors starting with 4 or 5 high-risk factors. So he did not find any of the high-risk factors.
You're saying substantial evidence, and that's the test. But I think tell me if I'm wrong about this. I've always found this, well, I find there are like layers of problems with, with these judgments, moderate, high, low, and so on. But even beyond that, we're looking so substantial evidence is a highly deferential standard of review, but it's now substantial evidence sufficient to support a finding by clear and convincing evidence? Is that?
Yeah. Yes.
Okay.
One
day someone will write an article about what that might mean, but all right, go ahead.
It's similar to saying, what in an SDP case, whether they have proven beyond the reasonable doubt that someone is likely to commit an offense. I mean, there are layers.
Okay, but the trickiness here is, there probably is sufficient evidence to come up with any classification here, but the question in my mind is whether it was explained adequately. Now, maybe that has something to do with, I don't know which other arbitrariness or something. To me, I don't feel like I'm in a position to say this is right or wrong, but I do agree with you, and I'll ask your brother about it, of course, that really it's a surprisingly thin opinion, that at the very end of the day kind of says like, hey, it's a pretty bad offense, so we're going with 3. And it is a pretty bad offense, but there's lots that, and so I don't know how to judge that. There's lots that isn't here. We don't have a repeat offender. We don't have, and so on. And I would be more comfortable if the hearing examiner had spelled out, not just I find this, I give it a little weight, I give it this full weight, and so on, but it said, but when you look at this, it's a guy who did this outside and he's like that and da-da-da. And so I just think there's a high risk, my more support for the decision. But I don't know if I'm allowed to even look at that under a substantial evidence test.
I think you are. And I think there actually, you raise a good point that I think hopefully comes through in my brief, which is there are a couple of ways, a couple of things a hearing examiner needs to do to justify a decision. So first is to say, to properly apply the factors. And so this court can look at the decision and say, these are the facts available about X factor, and the hearing examiner's finding of that factor and weight of that factor is appropriate or not. So that's one thing. Then there is the totality of it is to say, okay, now that we have all the factors that we think the hearing examiner correctly found, if we, assuming those are all correct, would those factors, is there a world where those factors can get you to X level? Yes or no? And then the third thing is, if we are in a world where these factors get you to a certain level, did the hearing examiner explain how he got to that level enough to justify the decision? So it is very nuanced on all those levels, and I think I raise a little bit of each. So maybe I'll start at the smallest and work my way up. So the smallest is, did he properly apply the factors, and I raised two issues with the factors he applied. Those being the sort of these dynamic changing factors, how he treated the criminal history and how he treated the history of supervisory about supervision or parole or probation. I don't think he applied those factors correctly based on what he had, right? So now you look at criminal history, for example, and you can look at what facts are not in dispute. This criminal history not in dispute. This is someone who had 30-year-old felonies and then a trespassing in 2006 or something like that. Those facts not in dispute. The hearing examiner says, I give this moderate weight. I say that those facts, as accepted, could never support moderate weight. And so the application of that, the weight that he gave that factor is just wrong, right? There wasn't enough evidence to support how he put that factor. You look at the, sorry, the question?
No, I was looking at.
Okay. You look at the next one. The violation and whether he should have given that any weight. So he says, not in dispute, the violation was based on a GPS issue and a proof of residency and a GPS issue. The regulation says you need to consider the seriousness of the violation. Now, this is one of those where he doesn't explain it. So there might be a world where that is good enough. There might not be. He would have to explain it. All he says is, I consider this factor. There is just not enough evidence for that to be justified on this record. That is a problem. So a different kind of reason to attack the application of factor than the first one.
Well,
Okay.
I mean, I guess I'm just not sure. I mean, so what I am reading is his opinion, her.
Sure.
I don't know.
Him.
It was a he.
His opinion. And I'm just not. Let's say we remand this with very specific instructions, and at the end of the day, the hearing examiner says just what he says in his current discussion section. This is an attempted rape of a stranger in public on a jogging path or whatever, where luckily her screams got someone's attention and the police came. It's horrific. Level 3. Do we have to find, I mean, because I have my guess is that if we sent it back, we might see something like that. That's almost what this says.
So it depends on if you agree with me and how much you agree with me. And so what I mean by that is, what I was going to say next is, so once you have these factors, if you see this as saying, okay, there are 5 risk elevating factors he applied, two of which the criminal history and the community supervision he gave too much weight to. So in a world where you give less weight to those and you have those 3 other factors, my argument is that is not going to be enough to get to a level 3 just on its face. So that's one argument. And that's because none of these are high risk factors. The 3 of the factors are 30 years old, and 2 of them, like I say, should not be given much weight at all. So there's no world in which those factors with that weight get to a 3. Yes.
Before you get to your next point, because the one thing I didn't understand in your excellent brief was the conclusion. So if we agree with that, isn't what we do is say, all right, remand to level 2?
Yes, you can do that, or you remand with insurance. I mean, yes, I think that alone gets me a level 2, and the court can do that. So that is a good point that I guess I wasn't clear in the conclusion that that's one of the steps this court can take. If
I'm missing something. Okay.
I have a separate question. I don't read the factors necessarily the same way as Justice Rubin. In some instances, you're right. The hearing examiner simply said, I consider this factor. But in other instances, and I'm at Record Appendix 36 to 41, he goes through a description of the conduct at issue or the violation, explains why he gives it significant weight. Factor 13, for example, he talks about parole revocation. He talks about a GPS violation. He talks about a probation violation, and he talks about while being searched for the probation violation, he has several pairs of female underwear out of his pockets. This is concerning, he says. He talks about the history of non-compliance with community supervision being a further indication of lawless behavior. That's some fairly straightforward and detailed reasoning. In other instances, he discusses factors and says, I give it minimal weight or I give it increased weight. We've certainly seen hearing examiner decisions that have more detail, but we've also seen ones with less. I'm not sure that I agree with the argument that you make at pages 9 and 10 of your brief that the judge just listed the factors, but didn't give a sufficient explanation. That's where I'm struggling anyway with your argument. I'm not telling you which way we're deciding this case at all, but that's sort of my issue.
Sure, and I appreciate that. So I think a hearing examiner needs to say how much weight they're going to give a factor. So he has to do that, and he does do that in some instances. What he doesn't do is then take the step of saying how that factors in. So, for example, one that I don't disagree with him in terms of applying factors. He says, this was a stranger victim, and the regulations themselves sort of have a hierarchy of which victims are more problematic than others, and strangers are the most problematic. And so he gives that factor increased weight. I don't take issue with his application of that factor, or because it's a stranger victim, giving it increased weight. But all that does now is it gives you a factor. Okay, so one of the factors that's going to be part of his calculus is, the most increased weight to the kind of victim. Fair enough. And you can go through the factors and see if he did that correctly. The problem is, at the end, when he tells you why he's doing what he doesn't explain how much the increased factor of having a stranger victim, I would say 30 years ago, interacts with more current conduct and the mitigating factors that he cites to, for example, or the other factors that I think he puts too much weight on, for example, the criminal history.
What was the GPS violation that led to the probation violation? The residency thing, it wasn't mere homelessness, right? It was something like failure to give an address, or that was in the record before the hearing examiner though, right?
That was in the record. I apologize because I'm not sure if I put the evidence that supported that. My memory is that
you may well have. I'm just looking at the hearing examiner's report, and the hearing examiner doesn't spell it out. And what was the GPS violation?
That is one of the problems. The GPS violation is not having reception. I mean, there's a series of not having receptions, not calling in, that kind of stuff. So it wasn't that he couldn't.
I don't know what that means. How can you tell if you have reception?
Oh, sorry.
But if you go to inside a basement or something, I don't get that.
That happens, meaning that at some point the GPS monitoring office can't monitor because they've lost a read on the bracelet. So what they
but presumably there has to be a finding of some scienter, right? You can't just say like, what do you mean you went in a parking garage? Unless you're not allowed to go to the parking garage.
I wish
I'll ask your brother, may have more detail about that. I'm just trying to figure it out, because it's one thing if the GPS violation is you're near that school, right? And it's another if the GPS violation is, our equipment malfunctioned.
I wish more judges gave it more consideration when they were doing probation violations, but a lot of times things are just lumped in and you have a series of can't reach, can't contact, don't call back kind of thing.
GPS violation isn't not calling back.
It can be.
It can be called a GPS violation?
Meaning because GPS is trying to get a hold of you because they can't track you.
Okay.
They reach out, they have a phone that
track
you at.
Seems like it might very well also not have reception, but again, I'll ask your brother.
Right, that's one of the problems. I don't even know if there's that much evidence in this record about that, but it can't, basically once they can't reach somebody on the phone they have, a warrant goes out, and if there's a good explanation for it, they might be able to undo the warrant and the violation. If there's not, I didn't call you because I was doing something else. I don't know what, I mean, there's ways in which that, yes, can absolutely be considered a violation.
It seems that what makes this an interesting case that we typically don't see is, as you point out, the absence of the typical aggravating factors for a level 3 on the one hand, but on the other hand, we have a stranger committing assault with intent to rape in broad daylight, just a horrific crime. It's sort of why the law exists. And on top of that, you have this same person not complying with parole, not complying with probation. And as I said, having other sort of issues that are pointed out in the record that suggest he may have a tendency or be a risk of reoffending. So it really is maybe a somewhat unique case.
Interesting case. Your time has expired, so if there are no further questions, very good argument. Thank you. We will hear now from Attorney Doyle.
Thank you, Your Honors. Thomas Doyle for the board. May it please the court. I would initially say that the Superior Court was correct in affirming the level 3 as found by the hearing examiner, as substantial evidence does support this decision. First, I would point out that in relation to the application of the factors in general, this court wrote back in 2012 at John Doe 136652 v. Board at 81 Mass Appeal Court 639 that the regulatory factors are illustrative and permissive. An examiner has broad discretion over how he or she chooses to apply them. Now, that's generally. Specifically here, we have a situation where, yes, none of the first 6 factors were applied in this case. But as I noted in my brief, the regulations themselves take into account that doesn't give any more mitigating or aggravating weight. It doesn't mean that he's less of a danger.
Okay, but we see cases of child rape where the person is classified as level 2, that happens. And here's this guy, and I don't know how, I wouldn't, comparing atrocities is not really the game I want to get involved in. This is also atrocious criminal behavior, very frightening, terrible.
Right.
But are they all? I mean, if you read this, you'd almost think, and I of course, I agree with Justice Neyman that of course there's other stuff in here, and the one that catches my attention, probably like his, is ladies' underwear in the guy's pocket when he's arrested. Now, I don't know. I don't know what any of this is all about in one sense, I don't know. But it's not, if you had an expert opinion or something, someone come in and say, oh, we see this,
Right.
This is terrible. But it's very hard for me when I read the discussion section is a couple paragraphs. And really what it says, this is a pretty terrible crime. And I can't dispute that. Of course, that's true. But is it always a level 3? Is it not? Why this one? Why not 2? And I'm at a loss. I mean, we usually see, candidly, and this is also what Justice Neyman was suggesting, we see people who every 15 minutes, I mean, maybe they wind up as STPs, but we see people who are repeat offenders. They didn't start committing crimes when they were grown-ups. They've been doing it since they were kids, sex crimes, you know what I mean?
Yes.
This doesn't have that stuff, which doesn't,
Right.
sort of what I said to your brother. I'm not saying he's not a level 3, but after reading this, if the conclusion had been, I find he's a level 2 sex offender, I would have said, oh, okay.
Right.
Now he says it's a level 3. Am I supposed to just say like, oh, okay.
Right. I think the most important thing to remember first is, and I cite this in my memorandum too, is that every single one of these decisions, every single one of these petitioner plaintiffs, every one of these convicted sex offenders has to be classified on an individual basis. And to tie in what my brother said is, and this court has mentioned recently too, is you can't just have a checklist and say, well, this is there, this is there, this is there, so he's this level.
Okay, but that's what this seems like to me.
Well, I would argue, Judge, that it's interesting that my brother argues that, well, none of the first 6 high-risk statutory factors are present. That sounds to me like he wants a checklist. Well, this part of the checklist.
I agree with you that that's his argument, but what I'm suggesting is that what we have here is this one I give this much moderate weight, heavy weight, no weight, and so on.
Right.
And then at the end, this is a terrible, terrible thing. He did sex offender treatment, but hasn't made any progress. He violated probation recently, and parole before level 3. And I'm not saying it's not. I just don't understand why level 3 and not level 2, or maybe even level 1. Right? You could write an opinion that said he's only ever committed 1 sex offense in his life, horrific though it was. Do I think he's likely to commit further crimes? Maybe. Sex crimes? I don't know. One, you know, but I mean, I guess the underwear in the pocket makes us think. But even there, it's not like the opinion says he has ladies' underwear in his pocket. And I think that means X.
I think Justice Neyman, I would agree with him when he said, you have the section where he applies the factors. And then in his discussion, which I would also call basically a synopsis or a review of his decision, he does go into further detail on why or why not he gave a certain amount of weight to each factor. The other thing I would point out, Your Honors, is that if you look at the board's regulations, and specifically 803 CMR 1.33, which is the factors, they are designated as the first 6 are high. So if one of those is applicable to you, that evinces a high risk to reoffend degree of danger. Then you have 7 through, I believe it's 29 maybe, or 28, forgive me. Those are risk elevating. So if any of those applicable, your risk is going to be elevated. Then you have the mitigating, and then you have the additional. All the last 3, elevating, mitigating, and additional were present here. And then you go into the nuance of, you know, how does it, when you have evidence to apply a certain factor, if, let's say somebody had a mental abnormality, you apply factor 1. Automatically, right off the bat, without any further analysis, that goes towards a higher risk to reoffend and degree of dangerous. Then you get into, once all the evidence is in and all the applicable factors are there, you analyze and you come to a conclusion of what level he is in. That's what was done here. So, yes, I think we all agree that the nature of the offense itself, the fact pattern was atrocious. Broad daylight, attempt to rape a stranger woman. But then you get into all the other things. And I know my brother argued that the fact that he violated parole or whatever, how many years ago. The fact is that he did violate parole, not once, but twice. I believe he violated parole on his index offense, but I would stand corrected.
Yeah.
Yes.
Do you know what that was? Do you know what that GPS issue?
I did.
I'll look and see if I can.
I look real quick. I do not, Your Honor. I apologize. You know, some of the things that inure to his benefit, at least one thing that inures to his benefit, is the examiner wrote that he gave him full credit. This is for an example for full mitigation. He's entitled to the mitigating benefit of this factor for advanced age. Now, at the time of the hearing, he was 49. At the time of the offense, he was 40, but age is determined at the time of the hearing. And the fact that he was 40 at the offense and 49 at the hearing, that might lead to a conclusion that reduces confidence that he was maybe aging out of his problem because.
But now you're arguing, I mean, that's fine. And maybe we need the hearing examiner to explain why, I mean, 49 is at least, I don't know about this, but in, you know, we see in other kinds of sex crimes, people talk about age diminishment of risk. I think starting at 60, maybe it's 50. I don't remember.
It's 50 for adult victims, 60 for children.
Yeah. Okay. So I've seen them both.
Yes.
All right. So he's only 49. I mean, but that's not what this. I mean, we're.
No. I'm not making that argument for the sake of it. I'm saying that he got full benefit of that, but it inured to his benefit that the examiner didn't give it any kind of risk reducing.
Nor to his benefit at all. He got the highest classification you could get. Right. He has
overall, yes. Overall, yes. I guess I'm arguing this wrong. I'm saying that if you look at the totality, you know, he did treatment, but he demonstrated little progress. He does have a criminal record, but it was dated. The examiner made a point of saying that. He only gave moderate mitigation for probation.
He said 3 instead of 2. Does the hearing examiner have to explain to us why this is 3 instead of 2? Let me ask you that.
I think by reciting the facts, the applicable factors, and then in his discussion, all within the section of where he applies the factors, he has done that, and he comes to a conclusion. He weighs all the evidence to the factors. He weighs how his risk mitigating against the aggravating and any additional factors which there were in this case, and he comes to a conclusion that based upon what he has seen in the totality, he's a 3 in this case. And you know, we all say it is a horrific crime, and it is a horrific crime. But then you add to that the risk elevating, the mitigating, and the weight he applied to each in his conclusion. And I do believe there is substantial evidence, by clear and convincing evidence, that this is a level 3.
So let's assume that, hypothetically, we say, geez, not every examiner would have classified him at this level, but there's substantial evidence to support it. Why is this case not one in which we should exercise the discretion that the SJC afforded us to remand this case for determination of whether dissemination is necessary in this instance?
Right. And you're speaking of DOE 496501, where they gave, the SJC talked about two reasons for remand. One is if the hearing examiner's findings are sufficiently explicit to enable proper analysis, but if the court finds that they are not explicit, the underlying facts clearly dictate the appropriate classification level. I would argue that the first one is applicable in this case. I would argue that his findings are sufficiently explicit to find a level 3 and that a remand would not be necessary for this court.
I thought sufficiently explicit in that regard meant that they were actually addressing the issue of dissemination.
Well, he did in this case. The hearing examiner did in this case, as in, I think it was DOE 23656, where the examiner, while he didn't make explicit findings to risk, danger, and efficacy of internet dissemination, he did write that I find his risk and danger is such that a substantial public safety interest is served by active dissemination of his sex offender registry information. And I would argue that, along with the sufficient explanation of the totality of the circumstances of this case in his decision, would not warrant remand.
You're at Record Appendix 43, correct?
Yes.
Okay. And ultimately, this is our discretionary call in that regard, correct?
It is, Your Honor.
Okay.
Unless there are any questions, I would rest on my brief.
Thank you both.
I see none. Yeah, thank you. Excellent argument by both of you, Attorney Doyle, Attorney Tennant. The case is submitted.
All right, we are live and recording.
Good morning, everyone. Welcome to the Appeals Court. I'm Justice Rubin, joined today by my colleagues, Justices Neyman and Ditkoff. The next case we will hear is actually a combined argument in two cases. Number 19-1788, DCF and another versus Mother, and 20-44, adoption of a child. And just a reminder to counsel, of course, these are impounded cases, so please take care not to use names, but only non-identifying titles, mother, father, and so on. So we will hear argument. Of course, we're doing this by video conference because of the pandemic, but the rules are the same as in our courtroom, which is to say 15 minutes per side and no rebuttal. And so we will hear first from counsel for the appellants in both cases, which is to say mother and grandmother. And we will hear first from you, Attorney Ferguson.
Thank you, Your Honor. My name is Hugh Ferguson, and I represent the appellant mother on the care and protection petition and the appellant grandmother on the appeal of the denied guardianship petition. May it please the court. This is a very sad case of domestic violence, of a domestic violence victim who was trying to do the right thing, but got little assistance from the state agency charged with keeping families together. As a backdrop, mother and father got together in 2009. Father is 6 years older than mother. Shortly thereafter, they had a child. In 2010, shortly after they were together, the domestic violence began. A review of father's Corey lists 12 police reports with mother as the victim in all 12 of those. In January of 2012, mother was assaulted by the father, and following a police response was taken to the hospital. DCF opened a clinical case for investigation and about 3 months later closed it after assessment. During the assessment, the child was noted to be healthy, quote, appropriately dressed, and quote, well cared for. And mother was noted to have been consistent with daycare. Fast forward several months, father showed up at mother's apartment. Mother called the police and father was removed. It's important to note there was no contact between mother and father for the 11-month period between July of 2012 and May of 2013, when the child allowed the father into the apartment. Father held both hostage and beat mother repeatedly for 6 hours. They escaped when father fell asleep, and mother reported the incident to the police.
Well, we know the facts quite well, I think, having read everyone's briefs and the opinions below. And of course, we get to the point where the child is, notwithstanding what the mother says, and without knowing everything about how it happened, left alone in the house, where there are, I don't know, strangers, I feel like drug users. She's supposed to be with, we're told later, an 18-year-old cousin or something, but that person's nowhere to be found, and neither is the mother, and she's removed. Maybe you can pick it up from there.
All right, Your Honor. Pardon me. Thank you. At the time the child was removed, it's important to note that mother was following a service plan requirement, which was to find suitable and appropriate housing. She testified that's where she was that morning, and there is nothing in the record that would indicate that this 18-year-old cousin was anything other than an appropriate caretaker until that time. Clearly, with mother out of the home, she's not the one who allowed the inappropriate other people.
Oh, wait, it's her house?
It's an apartment that she rents, Your Honor.
She has an apartment, and there's some, I think, maybe I'm making this up, these are crack addicts are in her house?
That is the allegation, though it's important to note, Your Honor, that the police report from that investigation was not included in the evidence.
About the fact that a building maintenance worker reported that drug users were frequently entering and leaving that apartment, and the child was often playing outside without supervision.
I can't talk to that, Your Honor, though it is in the record. Mother would tell you that that's not accurate.
But credibility determinations have been made, and as I understand it, you're not challenging those determinations as clearly erroneous on the appeal.
No, not as clearly erroneous on the appeal, Your Honor. There's other issues that I think are far more important than that. I think one of the things that is important is statements by the trial judge during day 7 of the trial. And I would quote from one of them, "My reading of the evidence is that she really did pretty much everything we ask a victim of domestic violence to do. To the extent she went to the Women's Center, she changed her phone number, and she ended the relationship." The judge continued, "The department's own assessment from a prior social worker makes notation of the fact that she was adequately protecting herself and the child from continued domestic violence. There's been no further incidents of DV, and the last incident was the little boy letting the father in. She didn't invite him in. She, quote, I think she did everything we ask our victims of domestic violence to do." That was 5 years after the case opened. So a big part of this argument is, what was the department doing for 5 years while mother, at least early on, was fully complying with the service plan? It did fall apart later, and we'll discuss that. Very important to note that at the time of that assault, the department did not remove the child. It was only 2 months later, while mother was looking for housing, that the child was removed. And once the child was removed, a service plan was put together, and a major piece of that was to find safe and appropriate housing.
Has she done so?
She, as the record indicates, Your Honor, she was looking for housing consistently, but as you also read in the record,
She lost her Section 8 voucher through her own failures, apparently, at least according to the findings of fact.
correct.
Right.
And market rate rent is very difficult anywhere in the Commonwealth.
Sure.
And she was doing the best that she could under the circumstances.
But she couldn't have taken the child on the day of trial, right? She didn't have stable housing even as of the trial. Am I right about that, or am I mistaken?
At the time of trial, Your Honor, I think she had just acquired housing that she was paying full market rent for, and could have taken the child. Had the department looked at what was the real issue, which at the time only was that the child had been left with an inappropriate caretaker. This child should have been placed with mother years prior and adequate services provided so that she could have maintained housing, so that she could have gotten the services that they were asking her to follow through on. This case just went on interminably to mother's detriment.
Can I ask you about the adoption case? I know we're talking about her fitness or lack thereof and whether it's going to continue into the future. How can the judge grant an adoption petition of someone who won't reveal her criminal history? How could they do that? I mean, maybe there's a short answer, but I don't understand what it is that should have happened here.
So, Your Honor, what should have happened there is that the judge should have taken notice of the fact that the grandmother's record was sealed 10 years prior to the time she presented herself to be a guardian. Nothing, and also recall that DCF did a background records check, and this woman had no contact with DCF. And it's important to note that—
So let's say I get I don't know how you get a record sealed. I thought it was very hard here, but maybe I'm mistaken. Let's say the record that is sealed involves a series of crimes against children, but it's sealed now. Surely, before letting someone adopt, a court can ask, or am I mistaken? You think it's off limits?
I'm not arguing that it's off limits, Your Honor, but what I would say is that if there were a crime against children, it would have shown up in the DCF's background record.
Not if they were stranger children. The fact that she had nothing to do with DCF. I mean, I'm not saying that it was anything like that. I have no idea. But all I'm saying is, don't you have to let the judge see that so the judge can assess whether it has any impact?
Recall also, please, Your Honor, that this lady had adopted a child.
Well, I saw that also. Now, I don't know, is DCF involved? If they're not involved in all adoptions, right? Only children that are in the system, I take it. So do adoption studies have to be done? Was any of that in the record?
An adoption study does not have to be done, Your Honor. However, when a person presents a petition for a guardianship or an adoption in the probate court, the first place the probate court calls is the Department of Children and Families to ascertain whether there's any background record on them. So I would submit to the court that clearly there could not have been, or the probate court would have picked that up when they did the review for—
Counselor, can I take a slightly different tact on this?
Yes, Judge.
Let's assume for the sake of argument that everything the judge did about the criminal record was wrong. Let's just assume that. Considering that the child is thriving with the pre-adoptive parents, and there's testimony to be traumatic for the child removed from the pre-adoptive parents, and that the grandmother has pretty much run out of money and has no source of income, how could it possibly be the case that the judge would not determine the pre-adoptive parents was the better placement?
The first thing I would say to that, Your Honor, is that one of the things the grandmother testified to is that she was at that time living off of a settlement. She was on disability, but because of the structure of the disability system, she was not allowed to draw disability payments while she still had money. She subsequently, when the money ran out, she subsequently would have been placed back on disability. And remember too, please, that she's at the same time parenting a 14-year-old child and making do even before the settlement that she was then living off of.
But the question isn't whether grandmother is unfit. Once
Correct.
we terminate mother, it's just a question, what's the better placement? How could the grandmother placement be better than the pre-adoptive parents with the child is bonded to and with whom the child is thriving?
5 years later, the questions you're asking, Your Honor, are incredibly important. However, at the time that grandmother first presented to be a placement resource, the department absolutely just denied studying the home because they said that she had criminal charges. Not that she didn't have money, not that she wasn't able to care for the child, but that she had charges and that she would not consent to open up her record.
Didn't the judge make a finding? I'm sorry, go ahead.
Doesn't the judge have to decide what the proper placement is after termination, not well before termination?
Correct, Your Honor, and that's why you'll note in the record that the judge made a decision as to mother and then had to withdraw that decision so that the guardianship petition could be heard. Was there another question, Your Honor?
No, Justice Ditkoff asked my question. Thank you.
Okay. I see my time is wearing down. I think it's important for the court to remember that there was testimony that mother was doing all of those services expected of her up to the time when the adoption or the goal for this child was changed to adoption. At that time, she fell off of the services that she was doing. And if we go back and really think about what this case is actually about, it is that mother left her child with an inappropriate caretaker. A police investigation was happening in the neighborhood. The police were in her home with a warrant, and the child was found to be without a caretaker. There were or were not other people because that police report was not entered into evidence. But I would submit to the court that this is a huge price for a mother and a child to have to pay for what is essentially poor judgment, that mother is now being held to a standard that we would not want ourselves held to.
Do we know why the goal was changed to adoption when it was?
It was changed to adoption, I believe, 8 months after the clinical case opened. And my reading of it, I can't tell the court why the goal was changed to adoption, because at the time the social worker testified that mother was substantially in compliance with the tasks. And as you'll note from the brief, the tasks started being added on as compliance occurred. So I'm noting that I don't have an awful lot of time left. So I would like to just go in and say that mother paying a huge price for a lapse of judgment on the day that a police investigation occurred. The child is paying a huge price too. And although the many years have passed, I believe he was 4 and he's now 11. Although many years have passed and he's bonded, was mother unfit based on that lapse of judgment at the time? And I would submit to the court, no, she was not. Further, as to grandmother presented herself early on in the case. She was at least due the courtesy of a home study, but the department denied that to her. And barring any other questions, I'll rest on my brief.
Thank you very much. We understand your argument and an excellent job, both orally and in your brief. So thank you very much, Counselor. We will hear now from you, Attorney Peterson.
Morning, Your Honors. My name is Jim Peterson, and I represent the Department of Children and Families in this case. I disagree very much that this was solely about a single incident and that incident was what happened at the time of the removal. This case originally started out, this case is, there's a significant amount of evidence that demonstrates mother's unfitness that goes beyond just that. Starting with the domestic violence that began all through her relationship with father back from 2009. And between then, 2010 and 2013, there were 12 police reports. This is all while mother has custody of child. Well, mother does not remove herself from the child and child from father. The 12 police reports, these incidences, mother ultimately, barring the most significant one at the end, she only gets 2 restraining orders and doesn't extend either of those. They expire after about a month. But both of these, we know that in 2011, twice she's punched in the face. In 2012 and in January, she's punched in the face again and has to go to the hospital. That's when the department gets involved for the first time. So that's when the family comes on the radar. The department asks her to go to a domestic violence class. She does it. She goes through that class, and then the case for services is closed at that point in April of 2012. Despite this, and you see in another year, a big thing happens. During this period of time, mother herself admitted that over several occasions in the past year, she had been assaulted by father, and she had not reported any of those assaults to the police. That was in an assessment that's contained in the record. This is after a 2013 incident. This is the one that Attorney Ferguson was discussing. Father broke into mother's place where she was at that time and assaulted mother severely. She was charged with kidnapping, assault with intent to murder, and child was there at that time as well. And the department did not remove the child at that time because mother did not invite father in, hadn't brought him over, any of that. At that time, it appears the child had let father in at that stage. But prior to, between the first incident that we had closed in 2012 and that 2013, there were incidences. And it's unclear exactly when mother stopped contact, although she said she did that. She also claimed that she had had no contact with father or had broken up with him. I want to say as early as far earlier than the 2012 incident, and the judge expressly disbelieved that. But in this case, we know that, as again, mother had admitted over that past year that these things had happened, that she hadn't reported them. And even so, other people did call in during that time with reports. They came out once, and as Attorney Ferguson mentioned, it was a restraining order violation that mother was cooperative, but later they also had another.
Counsel, before you run out of time, I'd like to talk about grandmother's criminal record. The sealing statute says that DCF can file a motion to seek to introduce the sealed records into evidence. I didn't see any motion on the docket. Am I missing it?
No, and in fact, if I can explain the procedure that happened, because I think that helps explain what happens. First, we went on to this, there's a termination of parental rights issue. Department presented its plan. This is the plan with the fathers and child, and a decree issued. Then the decree was vacated, and there was a private adoption petition by grandmother. At a private adoption petition, grandmother would have had the burden to show that her placement with her is the best interest. However, as it started, and on the first day after argument, the judge, after argument from grandmother's attorney, the judge at that point treated this as if it were a competing plan case. The department put on the case, all the parties participated, everybody had an opportunity to cross and bring witnesses, and then the decree reissued. And it's important to know that for your question, because what happened was, at one point, mother has the responsibility, or grandmother rather, has the responsibility and the burden of presenting this. And the department objected to the way this was going to play out, that somehow this is going to be a competing plan, but the judge wanted to do it. So it's on the day of trial when the department realizes this is going to be treated differently at that stage. So there wasn't a motion. Perhaps this would have been done differently had this been something that there was more advanced notice of that, but that's speculation. There wasn't a motion on that.
So if there's no motion, the statute says that such sealed records shall not be admissible in evidence or used in any way in any court proceedings. So how is it consistent with that statutory language for the judge to draw a negative inference based on the records that cannot be considered in any way?
Except in imposing sentence and subsequent criminal proceedings, and except that any proceedings under sections 1 to 39L, inclusive of chapter 119, which we were under 119, section 26 was the original termination best interest trial, or inclusive of
Except in those situations, the other party can file a motion to introduce the sealed records. That's why I started by asking that. Since you didn't do that, aren't we back in, it can't be considered in any way?
I don't believe we are. because it is admissible. It's something that would have been admissible. It is absolutely, with the Criminal Justice Reform Act of, I think it was 2010, where a lot of this was updated, it's not normally usable. But as Justice Rubin had noted before, we're talking the placement of a child. And as the statute goes on, as it talks about under Chapter 210 and under the 119, these are admissible. And yes, it does give a procedure, and that procedure wasn't there, but this is admissible. This was always something that would have been okay. And we didn't actually enter the record. And furthermore, grandmother herself had the opportunity, first of all, had represented she was going to present the record, which also may have affected whether DCF actually filed the motion pursuant to 276-100A. But she had that opportunity to rebut this, to make sure that it was not the department's position or the department's take on the record that was there. And the judge was aware of that. And the judge did find that it was grandmother's lack of willingness to be forthright about this that was the issue. She needed to determine what the record was. And grandmother had minimized the record. Grandmother said that it was, very small. It was wrong. The judge did not credit that minimization, but either way, had it been, it was something that the mother or grandmother could have presented to the judge so that the judge could have seen it in herself.
Your time is expired, but I'm going to let you, since it's two cases together, we can keep going a little bit if people have more questions. So go ahead. I'm sorry.
Thank you. And this is one where, again, it did come in a description of it. The department had seen the record. We know these records are previously in 2013. It had not been sealed actually for 10 years. It had been sealed sometime after 2013, November of 2013, which is when she had originally applied to become a placement for child. And the department had seen the record, had a copy of the record, and unfortunately lost the record in the meantime. But several people had had notes of this and knew what was in it, and this testimony came in. And in fact, the guardian ad litem for the child in another incident when grandmother a couple of years later had asked for a grandparent visitations, and the guardian ad litem didn't think that was in child's best interest. She had also, in a report that was entered into evidence, described some of that record.
In evidence in one of these two cases.
And actually in this case, that secondary part, the adoption petition slash.
Yeah, can you explain to me a private, I don't really understand, a private adoption petition was filed for a child in DCF custody? How does that happen?
Right, it's a little unclear exactly from the record. However, what appears what happened is we removed the child in August of 2013. Grandmother tries that year to become a placement. We see the record and say, no, that's not going to happen. You have a record, but there's a waiver process. She comes back a couple of years later. I want visits. And we know there's a record. DCF said, okay, there's a waiver process. In fact, we sent her, she wanted a copy of the letter, the original refusal, the reasons for it. And she wouldn't tell DCF where to send it. She didn't tell, as far as I can tell, DCF did not know where grandmother lived until the date she testified to it in trial. There was, this, which is consistent with her rather evasive behavior through that trial. So when she comes to pick it up, though, she's explicitly told there is a waiver process. We can go through this and we can try to get you visits. Grandmother never did it. It appears that she then tried to intervene in some way in the case. And it's not clear because it's not something that was part of the TPR itself.
I'm trying to find out how she came to file a private adoption petition.
And prior to this case actually going to trial, so ultimately she files a private adoption petition that gets held in abeyance apparently by the judge until after the termination of parental rights, presumably because—
Who is the defendant in that case? You? The DCF?
No, well, that's just it. It became that way because suddenly it gets joined as a consolidated matter. Procedurally, this could have been done in a far better way. It's these things should have.
An ordinary competing plan in the termination case, I would have thought, right?
Correct.
What we normally do.
And I'm unclear exactly why that never was presented during the trial, except that by that time, by the time, and you'll notice that's the later docket, 20, well here, but even below, that happens after the fact. It's this adoption petition that's out there hanging there, private adoption petition while the department has custody of the child prior to the termination, presumably because if mother gets the child back, then they don't want to go forward with it, but it's not clear from the record. And
we will look, obviously we have docket sheets and so on.
Yeah.
Let me ask you one last question. Do you know why the goal was changed to adoption when it was?
Yes, it was, mother was not engaging, contrary to, it is in my brief, mother was not engaging with services, and she was already, at that point, very early on, was not being consistent with visits. These aren't things that were falling down later. The visits issue, which I didn't discuss here, but it's very spelled out in the brief and in the findings, mother missed a great number of the visits and just did not have any consistency. Those were the primary reasons.
Are there other questions from either? Okay, thank you very much. Another excellent and very helpful argument. And we will hear now from you, Attorney Kruger.
Good afternoon, Your Honors. Yvette Kruger here, representing the child. I would, with respect to make a quick couple of points with respect to the paternal grandmother. I would submit to the court that the list of the charges is actually in evidence in a document, Exhibits 5, in the adoption petition that lists several firearms, intimidation, robbery, larceny, and committed to jail. She also testified that she spent 2 months in jail, although she wouldn't say what for. Cites for that are the Record Appendix Volume 5, pages 24, 26 to 28. That was from the Family Resource application that's in 2013 that states it's her initial eligibility screening that states she was denied because of a lengthy criminal history. The second document was the April 2015. It's an official letter from DCF to paternal grandmother denying her for an adoptive or a foster placement due to her lengthy criminal history and prior DCF history. And I believe that is the one that lists the charges. No, I'm sorry, the 2013 document lists the charges. Secondly, I would say that even if the statute, for some reason, I admit to not being familiar with the statute, requires this court not to consider it, I think it's still a fair and reasonable inference, certainly not an abuse of discretion for the judge to find an adverse inference against the paternal grandmother for valuing her silence over the importance of adopting her grandson. Thirdly, I would add that even without her criminal history, the question before the court was still the best interest of the child, and the best interest factors far and above outweigh, favor the pre-adoptive parents rather than the paternal.
Is the child still in the same placement?
Yes, Your Honor.
Have you spoken with your client recently?
A couple of months ago, Your Honor.
Okay.
Actually, 1 month ago.
Okay.
With respect to Mother's Counsel and stating that mother has paid a high price, I would say that in this case, it's the child who has paid a very, very high price for mother's not lack of judgment in one instance, but for her inability or refusal to acknowledge the very severe violence, the harm to this child over many years, and refusing to acknowledge the seriousness of it as evidenced by her failure to extend restraining orders over and over again. In fact, after all of this culminating in a hostage situation that involved her son, and even after that, she had to be warned by the investigator that she needed to extend the restraining order. If she didn't, she would be the one who was held accountable. So in addition to all the points made in my brief, I don't want to get too much into mother's unfitness, which I believe is overwhelming, unless your honors have questions. No? Okay. I would say the high price paid by the child resulted in this. He was removed at 3. At trial, he was 8. He's now nearly 11. This child needs and deserves very badly permanence. The record is very clear that he overwhelmingly looks at his pre-adoptive parents and pre-adoptive brother and grandparents as his family. He is close to them, he is bonded, and he would suffer a traumatic loss. And that mother demonstrably does not have the ability to be sensitive to or to meet his extraordinary need for services were that removal to occur. The pre-adoptive, the child, there's had significant, challenging, very difficult behaviors for a long period of time, was in therapy, has been in therapy for years and years, supported by the pre-adoptive parents. They have brought him to therapy. They have worked with the therapist. They have worked with the school. They have provided him support and a structured day, fully supervised 100% of the time, 24 hours a day for all of these years. He is actively engaged. He's one very lucky young man who has a network of family and friends and success in school and friendships that is the envy of probably most of us. And I don't believe there's anything in the record. It would be contrary to his interests for the paternal grandmother to receive custody or for custody to return to the mother. I think, the only reasonable alternative is adoption by the pre-adoptive parents, where this child has thrived, has significantly, the judge found, has tremendously improved in their studious care, scrupulous care. And it's time to say enough, Your Honors, if Your Honors have any questions.
Seeing none, thank you for an excellent argument. All three of you have been very, very helpful to us. Excellent arguments and briefs, all of you. Thank you. The case is submitted. Cases are